Afternoon, members. This is item 3, Maternity Protection, Employment Equality and Preservation of Certain Records Bill 2024, a Seanad Bill amended by the Dail report and final stages. I'd like to welcome back to the House once again Minister O'Gorman. You're very welcome. Now, this is a Seanad Bill which has been amended by the Dail, and in accordance with Standing Order 148 is deemed to have passed its first, second and third stages in the Seanad and is placed on the order paper for report stage. On the questions the bill be received for final consideration, the Minister may explain the purpose of the amendments made by the Dail, and this is looked upon as a report of the Dail amendments to the Seanad. For the convenience of senators, I have arranged for the printing and circulation to them of those amendments. The Minister will deal separately with the subject matter of each related group of amendments. I have also circulated the proposed groupings in the House. A senator may contribute once on each grouping. I remind senators that the only matters that may be discussed are the subject matter of each grouping of amendments made by the Dail. So the question proposed that the bill be received for final consideration, and I'm now going to ask Minister O'Gorman to speak on the subject matter of amendments in Group 1. Go ahead, Minister.
Thank you very much, Acting Chair. Appreciate your guidance there. And just if you'd indulge me for 1 minute before I speak to the amendments of Group A, I would really like to warmly welcome 3 women and their families to the House here today for this important matter. And having experienced the terrible news of a cancer diagnosis during their pregnancies, Erica Tierney, Mary Canavan and Emma McGuinness have all campaigned tirelessly to ensure that women who are diagnosed with cancer during their pregnancy can pause their maternity leave while they receive treatment. And from now on, any woman with a serious illness, be it physical or mental, will now be able to avail of this pause in their maternity leave, and it is because of their generosity in sharing their own personal stories that we are here today to see this particular piece of legislation enacted. And I'd like to give a special welcome to Rosha, Erica's daughter, and Killian, Mary's son, who are here to support their mums today. I really want to thank the Irish Cancer Society for their work in supporting these wonderful women to tell their important stories. We'll be one of the first countries internationally to legislate for a deferral of maternity leave in cases of serious illness, and I think we can all be very proud of that today. So I just want to welcome all the families and thank you for your work to date. Should also probably reference and welcome my own mum and dad and my uncle George and recognise their tireless work in helping me and allowing me be here today as well. Chair, the amendments for this group are largely technical in nature. Amendments 1 and 15 propose a change to the short and long titles of the Act, respectively, to reflect the proposed addition of sections related to non-disclosure agreements and preservation of records, which were not part of the published bill. The first amendment further provides for the commencement of different sections of the Act. Amendment 2 adds a standard provision related to expenses incurred in the administration of the Act. Amendments 3 and 4 are of a technical nature, changing wording slightly and correcting a cross-reference, but with no change to the intended purpose of the amended section. Amendment 8 provides for the Minister for Social Protection to make regulations to allow for maternity benefit to also be postponed in line with the provisions to postpone maternity leave. This is necessary to ensure that when a person who is eligible for maternity leave and benefit avails of the option to postpone their maternity leave, they can also defer their maternity benefit at the same time.
Okay, thank you, Minister. Does any member want to come in on Group 1? If not, I'm going to ask the Minister to speak to the subject matter of amendments in Group 2. Please, Minister.
Thanks.
I think it's just Amendment 6. Go ahead.
That's Amendment 6, I think. Yeah. So this proposal related to maternity leave for members of the Oireachtas was carefully drafted with the Office of the Attorney General to avoid any perceived overstep in relation to the separation of powers. However, given the subject matter of what we're doing, we're allowing all women to have the ability to defer their maternity leave in the event of serious illness. It would be strange at the same time that we're providing maternity leave for Oireachtas members not to provide the same right to them. So this Amendment 6 is just clarifying that and ensuring that female members of the Oireachtas, if they become seriously ill during their maternity leave, have the same rights to defer it as all other women.
Thank you, Minister. If I don't have any members on that group, I will ask the Minister to speak on the subject matter of amendments in Group 3, which is Amendment 7, I think.
Very much. So this amendment inserts a new section 14b into the Employment Equality Act 1998 in order to introduce measures to limit the use of NDAs where an employee has alleged discrimination, harassment, sexual harassment or victimisation. The proposal provides that such NDAs may be entered into only if requested by the employee and with the legal advice provided at the employer's expense. The amendment lays out a list of conditions that must be met in order for such an NDA to be enforceable. It must be set out in writing, be in accessible format, have a 14-day waiting period to allow employee to withdraw from the agreement, be of unlimited duration unless the employee elects otherwise, include information about who the employee can make disclosures to, and this includes a Garda, a legal practitioner, a registered medical practitioner, a mental health professional, an officer of the Revenue Commissioner, the Ombudsman, a trade union, or such individual or member of such class of it as individual as may be specified within the NDA. The NDA proposals were included in the general scheme and have been considered by the committee during pre-legislative scrutiny. The amendment further proposes to exempt NDAs which are agreed through the Workplace Relations Commission's mediation service. And these proposals build on a previous private member's bill sponsored by Senator Lynn Ruane and Senators Flynn, Black and Higgins. And as we know, that member's bill passed all stages of the Seanad. And as you know, my own department did a consultation on the equality legislation, and a section on the NDAs was one that we had significant feedback on, and just want to note my appreciation to Senator Ruane for her work and cooperation with myself and officials in terms of advancing this important piece of legislation.
Thank you, Minister. I think Senator Ryan, you'd like to come in? Go ahead.
So I think just to, I suppose, mark the legislation coming back into the chamber today, and Minister, you did say at the committee that you would move heaven and earth, and I was still looking at you sceptically. So I would like to now take that back. And
every day, so I think we should all celebrate.
But as you can understand, it's when things are out of your power, and you spend so long working on something, and then you hand it over, and you have to kind of give over and suspend all, I suppose, power or hand you can have in and what happens next. And I think because it's such groundbreaking legislation, there was always a concern that there would be enough pushback on it that it may not happen. So I just want to acknowledge yourself and your officials and your department for obviously initially supporting the legislation that I brought through the House, but then expanding on that in terms of your own research and seeing how important it was that we continue to see it through, and for it to become law in Ireland. Last night there was already communication coming to me from the UK, from America, from Canada. Everyone seemed to be well tuned into what was happening in the Dáil last night. So it is a global groundbreaking piece of legislation, and I think the intention of it should always be that if a victim does ask for an NDA, that NDA is about protecting the victim. It's never about protecting the perpetrator, which obviously then hands the power over to the victim whether they want to enter into one or not. But also ensuring that other people are not expected to collude in any shape or form with an NDA, and I think that's something that needs to be worked out in terms of when people enter into it, because obviously we don't want to be given references for people who have potentially committed any sort of potential crime or harassment or bullying, and it's important that we don't then pass them people onto unsuspected other services or sectors. And the use of NDAs has never been about people, human life and the things that happen to us. NDAs were ever only about protecting patents and trade secrets. They were never supposed to be used as a tool or a further extension of silence and abuse, and I think we have moved really far now in actually ending that practice, but also setting that moral standard of other people in terms of when they do try to coerce or suggest to somebody that they should enter an NDA, that it is a silencing tool. It should be seen as bad practice. We should expect our solicitors, our union reps, all to be so good at their jobs that they're negotiating always in the best interest of their client or the person that they're there to support in the long term, not just in that immediate moment. So I again would like to thank you. I would like to thank the staff in my office as well, who have continued to, right from the drafting of the legislation. Seb McAteer is here today. He drafted the original legislation that passed this House, and then my own office, we've continued to have lots of global meetings. Last year we had a great event where we brought Zelda Perkins, who was the fourth person to break the Harvey Weinstein NDA. We had a big event here in Ireland that was well attended, and well attended by people who couldn't contribute on the day but were there because they signed NDAs but they could never share their story. So I hope today that somewhat they see that in the sharing of their experiences with myself and then with your own department department over the last few years that it has created a monumental change in how we view NDAs and how they should be used. So I obviously welcome the amendments here today and appreciate, I suppose, the way in which we've worked over the last couple of years. So thank you.
Senator Ruane. Senator Sherlock.
Yeah, and I just want to very much welcome that we're finally here, Minister, with this bill today, and obviously the campaign fought by the Irish Cancer Society has obviously been long fought, and we spoke about this 2 weeks ago when this bill was before the Seanad. So to very much welcome the work by your department and by yourself, Minister, in eventually bringing this, and obviously there's been delays along the way. I think I also just wanted to say that in terms of, just to follow on from Senator Ruane there, in terms of the inclusion here of the section on non-disclosure agreements is certainly hugely welcome, and is certainly, as somebody who worked in the trade union movement for many years and who had to sign up to non-disclosure agreements in the course of my work in terms of dealing with employers, and knowing that that paper was really not worth the paper it's written on, but for vulnerable workers who NDAs were very much used as an instrument of coercion, an instrument to silence, an instrument to effectively that would have very long-lasting impacts. And so I want to thank Senator Ruane for all her work on this. I do want to flag one concern that I do think we need to look at over the longer term. The accepted non-disclosure agreements that are provided for here suggest that an employee, that a non-disclosure agreement is, I suppose, acceptable or is permissible under this legislation, provided that an employee has access to independent legal advice. And I do want to raise a warning that, we have seen the legalisation of industrial relations, of employee rights now over the past number of years in this country, effectively elbowing out the trade union movement, trade unions in terms of being the true voice of representing workers, and I think there has to be space to allow trade union advice to workers in this. There's no doubt there have been all sorts of black sheep in the past, and I know Senator Ruane has referred to that previously, but the principle remains that unions are there to represent the best interests of workers, whereas sometimes if we have to engage independent legal advice, the cost and other factors associated with that are not necessarily in the workers' best interest. So I think it's something that we do need to look at in the future in terms of providing for both independent legal advice or indeed advice from the workers' trade union to protect the best interests of the employee in question. The last thing I just want to say, and I don't know if this is an order, Chair, but you'll bear with me for a minute, that as
before.
No, I know, but I'm
I've
just saying.
paying more attention now to
I'm saying it very, very briefly, right? Because ultimately, I raised this in the context of the second stage in this bill, and I want to raise it again. That to me, it is a huge disappointment that in the context of this bill, which seeks to recognise that women who go through a severe, serious health condition, a serious illness, while pregnant or just after giving birth to their baby, that we seek to distinguish between a physical health condition and a mental health condition, and that the criteria for recognising a mental health condition has to be inpatient hospitalisation. And I said it at the second stage, and I'll say it again. I think it's an absolutely antiquated view of mental health and its treatment. Somebody can go through cancer and never spend a day as an inpatient in a hospital, and yet we expect that somebody with a mental health condition has to be hospitalised. And I think in this day and age, it does not reflect how science, how medicine has progressed. And again, I said it at the time, I don't want this bill to be delayed in any shape or form. So this is why we're supporting it here today, but it does need to be revised into the future so that there is parity at the very least between those who suffer a serious mental health condition and a serious physical health condition, because I think it's a disservice to women who suffer a serious mental health condition that they have to be hospitalised in order to qualify under this bill.
I did let you continue because point well made. Now, Senator Siri Kearney, then Senator Warfield. Go ahead, Senator Siri Kearney.
I suppose we thank you, Chair. In the course of the Seanad last hearing, we didn't have the opportunity to speak about NDAs, so I just want to briefly address it. And first of all, congratulate Senator Ruane on her considerable work over many years in bringing this forward and highlighting this as an issue, the appalling bad practice of silencing people. And I want to acknowledge the people who came forward to her in fear, who discussed their situation with her, terrified of where it might go, and I want to congratulate her on holding the confidence of those people and yet moving forward with that information and empowering it through legislation. And that is really, it sums up what we're about. We're about here to make changes and to really better people's lives, and everything about this bill, in fact, from beginning to end, does so. So I want to really just remark that and show enormous respect. Thank you, Minister, and the Department for all the work you did in bringing it forward, ensuring, because I know that it has to pass so many barriers along the way before it can be included in legislation, that is fantastic, and it's great to make sure that they have that. I think that this sets a tone of a culture, and a culture of no tolerance, that where there is sexual impropriety, where there is complaints of that nature, under no circumstances can anybody collude in the cover-up of it. That anybody can just pass for a start, silence a complainant and a victim and a survivor of abuse, and they can't pass them on to somebody else, pass the perpetrator on to some other employee. And that we shouldn't have a situation where references are ever given to anybody in such a situation. There is no obligation in law to give a reference other than to confirm that somebody started on day one and finished on such and such day. That's actually the only obligation that there is. References and character references and the whole lot are wholly inappropriate. So the practice of doing that by employers, and particularly this began in academia, really, didn't it? That practice is just appalling. That people have been passed from one entity to another to continue perpetrating in another guise, all knowing that they are covered by silence. So I think today is a stop sign to that. Also to that culture and to any remote tolerance of it anywhere, that there is a mechanism out of it and there is a means of complaint. So I'm delighted with that. We need to be setting a cultural tone for our country and for what we will tolerate in society, and this is a fantastic stop sign. So congratulations and well done.
Senator Siri Kearney, now Senator Warfield.
And just on behalf of Sinn Féin, I want to welcome the Minister to the House and commend him for the work in bringing this bill forward. I also want to acknowledge as well the work of the Irish Cancer Society and the Leave Our Leave campaign that it ran, and as you've said yourself, I'm particularly mindful of Erica Tierney, Emma McGuinness and Mary Canavan, who selflessly shared their experiences of receiving cancer diagnosis during their pregnancies and being compelled to begin their maternity leave while also going through cancer treatment. So they're all very welcome here to this House today. And this legislation is indeed a recognition of their work and of the society's endeavours to ensure no women will again endure what those women had to go through. I welcome your proposal, Minister, around the expansion of the proposal beyond cancer to all serious illnesses as well. The impact that this bill will have for mothers and children and their families as well is immense and cannot be overstated. I do want to reiterate the concerns expressed by Senator Sherlock. We have concerns that the bill falls short in terms of recognising the many complex mental health disorders, mental health matters that can arise during pregnancy and birth. In particular, I have concerns about the stipulations surrounding inpatient care, and it's my understanding that the bill only relates to very serious mental health illnesses that require hospitalisation, and Senator Sherlock touched on that. And that seems to be contrary to best practice, like namely encouraging people to get support within their communities where possible and to use community healthcare where possible. But it seems to fail to give consideration to the full range of mental health illness that do not result in a person being hospitalised, but nonetheless do cause significant challenges and difficulties to a mother trying to bond with her child. So perhaps you might clarify that issue. I just thought I'd take the chance to mention that.
No problem. Thank you, Senator Warfield. Minister?
Thank you. Thanks, Senators, for the contributions. And just to Senator Siri Kearney, look, I think that idea of this as a sign of no tolerance is important. As you know, we have, in terms of our statewide response to domestic, sexual and gender-based violence, we have a national strategy, and zero tolerance is its title, and zero tolerance runs all the way through it. And I think situations where perpetrators are able to harass or sexually harass colleagues and staff and are able to get that hushed up, get it swept under the carpet, is exactly what we're trying to stop in terms of this. And that is one, that pervasive sense that of impunity is part, and breaking that is part of zero tolerance, part of that. So I see our work today very much feeding into our national strategy against domestic, sexual and gender-based violence. Senator Sherlock, just in terms of your point on advice and who the advice can be taken from, look, I take on board your point. I would note that when I listed out the people that someone can discuss an NDA with, we actually added in trade unions after some engagement with I think ICTU flagged that with us. So I think I've taken a step there to make sure that the role of trade unions is recognised within the process. I know it's a slightly different point to the one you're making, but nevertheless, I certainly see the value of good trade union representation in terms of what we're trying to do here. In terms of your point and that of Senator Warfield, I suppose when we originally, myself and the Irish Cancer Society originally met, the scope of this bill was cancer, was that women who suffered cancer during their maternity leave would be able to avail of this pause of their maternity leave, and about 50 to 60 women every year are in that position. My view was it would be inequitable just to restrict it to cancer when there were other women suffering serious illnesses that we should be including as well. So I asked the drafters to draft a broader definition. The initial definition that came back to me was broader, and we were using this term serious illness, and this right to pause is only for serious illness, and we just have to be clear on that. But the initial definitions were based on a physical illness, and I certainly wasn't comfortable about that. I think we all recognise the degree of seriousness that mental illness can have on anybody, and on a new mother. So I wanted to ensure that we did have protection for mental illness. In terms of our engagement, the definition, the way of including that as a definition was to use inpatient treatment. I see the limitations, and I'm not disputing your point, but in terms of being able to provide something ensuring that mental illness was involved here, was covered here, but also in terms of the wanting to move with speed. And I know you've spoken about supporting this and want to get it through. So look, as with all legislation, there's always an opportunity to look and tighten and improve definitions. But I just think it is important, while not disputing your point, just to talk about the evolution from cancer to serious physical illness to now including serious mental health illnesses as well. Senator Ruane, thank you for your very kind comments. When I make a commitment, I do try and fulfil it. And I made a commitment to you in terms of trying to get the NDAs through. I made a commitment to the Irish Cancer Society in terms of the Leave Our Leave campaign, and I made a commitment to some of those who'd engaged with me in terms of the protection of private records. And I'm pleased that today that, and then the fourth point in terms of maternity leave for female Oireachtas members. Late is the hour, I know that, but look, we've got that through, and for the people who will be able to benefit from the various provisions of this legislation, I think the fact that it is close to an election time isn't going to be of concern for them when they're able to actually avail of the new rights contained within this legislation. So thanks for your comments.
Thank you very much, Minister. So that concludes Group 3. And now I'm going to ask the Minister to speak on the subject matter of amendments in Group 4, which are amendments 9 to 14 inclusive. Go ahead, Minister.
Thanks very much, Chair. And the amendments in this group introduce a new part to provide for the preservation of the defined categories of records held by private actors, so they're preserved in the public interest. And I recognise this section came late in the day. I want to thank all the senators who've engaged with me on this particular point. We've held a number of briefings for senators and deputies, and I hope we've explained in terms of wanting to move fast with this particular protection. The private actors would include anyone who holds records in relation to mother and baby in county home institutions, Magdalen laundries, industrial schools, schools and reformatories and orphanages, as well as the bodies that ran or oversaw these institutions. It would also include those who hold records related to adoption agencies and those who are involved in placing people for adoption into a care arrangement, into an institution, or with the persons who assumed the role of parent to them, and therefore including illegal birth registrations as well. Amendment 9 defines the key terms used in the new Part 3, including relevant record, institution, relevant body, information source, and public interest. Amendment 10 provides that the Minister for Children, Equality, Disability, Integration and Youth may designate by order an institution, a relevant body, or a relevant record. So it means that we can actually, the Minister can actually add additional records, additional institutions or additional organisations to a list that will be covered by this particular piece of legislation, and is an important flexibility built into the legislation. So while the legislation aims to be as encompassing as possible, this section is included to ensure that any relevant institution, bodies or records that come to life and aren't covered by the bill now can subsequently be covered. Amendment 11 places an obligation on any private holder of a record to preserve it and makes it an offence to destroy, mutilate, falsify or fail to maintain the relevant record or to export them from the state. It also provides that the Director of the National Archives may direct a person or body to provide a statement outlining the relevant records in their possession. Amendment 12 provides for offences under the legislation. The offences mirror those set out in the Birth Information and Tracing Act 2022, namely on summary conviction, a Class A fine or imprisonment for a term not exceeding 6 months or both, or on conviction on indictment, a fine not exceeding €50,000 or imprisonment for a term not exceeding 3 years or both. Amendment 13 sets out standard provisions for the service of notice. Amendment 14 amends the National Archives Act 1986 to include the new functions assigned to the Director under the legislation. And as I said at the outset, legislation on this has been called for by survivors and former residents, affected persons, their families and advocates. They want to ensure that the records which support the understanding of their identity, but also the institutional systems which shape their life experience in such a significant way, are preserved, are maintained. And while the Birth Information and Tracing Act of 2022 was able to protect, preserve and allow access to private records to people's own individual birth and early life information, what we're seeking to protect here is the wider institutional records, the financial books, the ledgers, house rules, all those things that aren't directly linked to one person's information, but nevertheless are really important in terms of understanding how these institutions operated and their wider impact on the women and children who were placed within them, and indeed on wider society. So I'm bringing these amendments forward I brought them forward as a committee stage amendment to allow this urgent and important legislation to travel quickly through the necessary stages in the Oireachtas. Thank you, Chair.
Thank you very much, Minister. Senator Siri Carney, go ahead.
Thank you, and well done, Minister. I think this is a great piece of legislation, and thank you so much for the very thorough engagement that you had with us. And it was a very meaningful conversation about what this looks like and what will. And I suppose one of the things I really took away is that onus on preservation, and preservation to a standard that will be required in an archive may actually well mean that organisations and institutions will hand over the information that they have, and that because they will not be able to keep it to a standard that is requisite of an archive, and so that information is accessible and has been properly preserved. So I think I came away very reassured, actually thinking, you think about it well, will it be destroyed? Will it be moved to another country, as has happened in the past? We now have means of stopping that from happening. But also within this information that's out there, because it isn't personal data, because it is, given the narrative that you've given us, it tells us about the organisations and the experience of living there without it being any one individual's experience. So actually that will in itself will be meaningful. I want to take the opportunity while we're under this heading to also acknowledge the people who have received information based on the database that is already there and that was accumulated in the course and for birth information tracing, but also in the redress scheme. I have assisted quite a significant number of women through that process. And while I never thought, and I think I remember standing here cautioning that there may not be the information that people think is there for them, I've actually had quite the opposite. People have gotten information that has been extraordinary about a level of care experienced that they have no memory of, but the level of care around them. I had seen letters from local authorities of the time that were very cold and very transactional. But I've now had privy to seeing the letters of the adoptive parents of boarded out, parents who had children boarded out with them, and the level of care and actual concern and heart in some of those letters as well. So I've had the honour of being part of that process with people's lives, and how healing and restorative that has been. I didn't really anticipate that. I anticipated people knowing about themselves will be good and getting that, but not that extra piece. And I remember us talking about there may be teddy bears, there may be letters, there may be things like that. Actually, there were, much to my own surprise. So I want to congratulate you. I think for all of us, it was a very difficult process. I would wish there's a residual money there, if we can ever come back and review it in the future for the people less than 6 months, that we would do so. But I know there's a review built in. But I think that it was a process that you guided and you led in the face of great, we had a lot of political turmoil at the time. And so I want to congratulate you on that and say well done to your parents. You did a good job. So thank you very much.
Thank you very much, Senator Siri Carney. So that concludes Group 4. Minister, unless you want to come back in.
Just very briefly, thank you for your comments there, Senator. I think what we're doing here is significant. The preservation steps we're taking in this legislation is very similar to what was done in Northern Ireland about 2 years ago in terms of the wider institutional records. And they've already seen in Northern Ireland that it has led to private record holders surrender records to the state because they can't maintain those records to the standard that we're expecting here. And I expect something similar will happen once we implement this. The National Archives, under the National Archives Act, there is a facility where they can take receipt of private records. Since we passed the Birth Information Tracing Act in 2022, the same thing has happened. The ISPCC has handed over to the Adoption Authority of Ireland a very significant body of records. Some religious organisations have also handed records over as well. So the process and the steps we put in place under the birth information and tracing legislation kick-started that process. I think this will continue to deliver that. And just to say, in terms of birth information and tracing, and it's wonderful to hear those stories of people who've gotten genuine glimpses or indeed detail about their early life. There are people who still don't, and we have to recognise that. But 11,000 people have now used and received information under this legislation. Some of them have received the birth cert for the first time. Some of them have found out what their original name was. So this legislation, which we discussed in great detail in this House, has had very, very real meeting. Over 150 provided items have been handed over to people, items that were left. So it has had real meaning, real significance. And look, I think it is important to recognise that we were able to make a very significant change, a piece of law. And I think I remember saying during the debate when I was studying family law in university, this was the big barrier. Adopted people couldn't get their information. We couldn't bridge that gap, and we have been able to bridge it with, I think quite significant success.
Thank you, Minister. So that concludes Group 4. And now that the bill be received for final consideration, is that agreed? Agreed. And the next stage is? Now, is that agreed? Agreed. And that the bill do now pass? Is that agreed? Agreed. Okay, so that concludes item 3. I now move on to item 4, which is a motion regarding the earlier signature of the Maternity Protection Bill 2024 without debate. I'm calling on the leader, or the acting leader, Senator Siri Carney, to move the motion.
I move.
Is that agreed?
Agreed.
Agreed. Okay, so I think the question is carried. So that concludes item 4. I'd like to thank you, Minister, for being here. It's nice when you've got a piece of legislation that has support from all sides, and I think you've worked hard to get there, and I think congratulations to you and your officials on that, and equally congratulations to thank all the members for their participation in a process that has brought an end to a successful conclusion to this particular matter, and well done to you on that. I'm now going to ask the Acting Leader, Senator Thierry Carney, when to both sit again.
On the 5th of November at 1 p.m.
Is that agreed?
Agreed.
So the House now stands adjourned at 1 p.m. on Tuesday, the 5th of November 2024. Thank you all very much.
Great.